Chapter 1. What is O1 visa for the United States? The O1 visa is a non-immigrant visa category for individuals with extraordinary ability in the sciences, arts, education, business, or athletics. To qualify for the O1 visa, an applicant must demonstrate extraordinary ability in their field through sustained national or international acclaim, and their achievements must be recognized in the form of awards, prizes, or other forms of recognition. The O1 visa has two subcategories. 1. O1A, for individuals with extraordinary ability in the sciences, education, business, or athletics. 2. O1B, for individuals with extraordinary ability in the arts or motion picture and television industry. To apply for an O1 visa, the applicant must have a U.S. employer or agent who will file a petition with the USCIS on their behalf. The petition must include evidence of the applicant's extraordinary ability, such as documentation of awards, publications, or other significant contributions to their field. The O1 visa is initially granted for up to 3 years, and it can be extended in 1-year increments as long as the applicant continues to meet the eligibility requirements. The O1 visa also allows for dependent family members, spouse and children under 21, to accompany the primary visa holder to the U.S. and apply for O3 visas. Chapter 2. How to get O1 visa from outside the United States. To obtain an O1 visa from outside the USA, the following steps typically apply. 1. Determine eligibility. The first step is to determine whether the individual qualifies for an O1 visa. The O1 visa is reserved for individuals with extraordinary ability in science, arts, education, business, or athletics, or those who have demonstrated extraordinary achievement in the motion picture or television industry. 2. Find a U.S. employer or agent. The next step is to find a U.S. employer or agent who is willing to sponsor the individual for an O1 visa. The employer or agent must file a Form I-129, petition for non-immigrant worker, on behalf of the individual. 3. Gather supporting documentation. The individual must gather supporting documentation to demonstrate their eligibility for the O1 visa. This may include evidence of their extraordinary ability or achievement, such as awards, publications, media coverage, and letters of recommendation. 4. Attend a visa interview. Once the Form I-129 is approved, the individual must attend a visa interview at a U.S. embassy or consulate in their home country. The interview will determine whether the individual is eligible for the O1 visa and whether they meet the requirements for entry into the United States. 5. Obtain the O1 visa. If the visa is approved, the individual will be issued an O1 visa, which allows them to enter the United States for the specific purpose and period of time indicated on the visa. It's important to note that the process of obtaining an O1 visa from outside the USA can be complex and time-consuming. Chapter 3. The O1 visa provide the pathway to get permanent residency, green card, in the United States. The O1 visa can provide a pathway to permanent residency in the United States. As an employment-based visa, the O1 visa is one of the categories that allows for an immigrant petition to be filed on behalf of the visa holder, which can lead to permanent residency in the United States. If an O1 visa holder wishes to apply for permanent residency, they can do so through the employment-based immigration process, which requires a labor certification from the U.S. Department of Labor and an approved immigrant petition from the USCIS. The immigrant petition can be filed under one of the employment-based preference categories, EB-1, EB-2, or EB-3, depending on the nature of the individual's work and qualifications. The EB-1 category is reserved for individuals with extraordinary ability in the sciences, arts, education, business, or athletics, which includes O1 visa holders. If an O1 visa holder can demonstrate sustained national or international acclaim in their field, they may be eligible for the EB-1 category, which allows for self-petitioning and waives the labor certification requirement. It's important to note that the process of obtaining permanent residency through the employment-based immigration process can be complex and lengthy. Chapter 4. Stages to get permanent residency, green card, for O1 visa holder and his or her immediate family. To obtain permanent residency in the United States from an O1 visa, the following stages typically apply. 1. Labor certification. The first step in the employment-based immigration process is to obtain a labor certification from the U.S. Department of Labor. This requires the employer to demonstrate that there are no qualified U.S. workers who are able, willing, and available to fill the position offered to the O1 visa holder. 2. Immigrant petition. Once the labor certification is approved, the employer must file an immigrant petition, Form I-140, with the USCIS on behalf of the O1 visa holder. The immigrant petition establishes that the O1 visa holder meets the requirements for permanent residency in the United States. 3. Adjustment of status or consular processing. If the O1 visa holder is already in the United States, they may be able to apply for adjustment of status to permanent residency. If the O1 visa holder is outside of the United States, they must undergo consular processing to obtain an immigrant visa. 4. Conditional permanent residency. If the immigrant petition is based on a marriage that is less than 2 years old at the time of approval, the O1 visa holder will be granted conditional permanent residency, which requires them to apply for removal of conditions within 90 days of the expiration of their conditional permanent residency. 5. Removal of conditions. To remove the conditions on their permanent residency, the O1 visa holder must file a petition to remove conditions, Form I-751, within 90 days of the expiration of their conditional permanent residency. This requires the O1 visa holder to demonstrate that their marriage is still bona fide and that they continue to meet the eligibility requirements for permanent residency. It's important to note that the process of obtaining permanent residency from an O1 visa can be complex and time-consuming. If you really want to get further detailed information, please comment and subscribe the channel. We will provide you all the information, and you can apply O1 visa without the support of attorney and consultant. The average attorney or consultant will charge you more than $15,000 United States dollars. Additionally, they will charge the fee for your immediate family for O3 visa, and it will cost you around total $25,000. So, you may save your $25,000 by following the O1 and O3 video series, and get the U.S. permanent residency and citizenship.